Good afternoon. Attorney Protective would like to welcome you to today's webinar, Brick and Mortar No More, Ethical Issues with Multi-Jurisdictional Lawyering. For information about today's speakers, Micah Bookdahl and Kate Gould. And with that, I would like to introduce our first speaker. Kate?
Thanks so much, Erin. And thanks again for joining us today. You'll see on your screen that we have a great webinar for you today. We are so pleased to have Micah presenting for us on multi-jurisdictional practice. He is truly a thought leader in this area, as well as someone who can offer great practical guidance as well. Today, we're going to review ABA model rules that govern this area, examine how individual states are addressing multi-jurisdictional issues, how you can maximize the versatility of your law license, best marketing practices. We'll look at some attorney discipline matters, and also see where things are heading in this area. As usual, we'll conclude with our Q&A session, so please have your questions ready. With that, we'll jump into Model Rule 5.5. So you'll see on this slide, we've included the text of Rule 5.5 for your reference throughout the webinar. We'll take a minute as we get started to walk through the subsections of the rule and the associated comments. Subsection A, this one's fairly self-explanatory. In the comment associated with this subsection, it states, a lawyer may practice law only in a jurisdiction in which the lawyer is authorized to practice. Of course, this could be where you are admitted or otherwise authorized on a limited basis. It applies to the unauthorized practice of law by a lawyer, whether through their direct action or by assisting someone else. As for subsection B, the comments explain that a lawyer violates this rule if they establish an office or other systematic and continuous presence in a jurisdiction for the practice of law. And that's a phrase you're going to hear throughout the webinar today. Mike is going to delve into this quite a bit as it relates to marketing and advertising. And the comment seems to reference that when it further explains that your presence may be, in fact, systematic and continuous, even if a lawyer is not physically present in the jurisdiction. Next, subsection C permits a lawyer who's admitted to practice in another U.S. jurisdiction who's not disbarred or suspended from practice to provide legal services on a temporary basis as long as the circumstances do not create an unreasonable risk to the interests of the client, the public, or the courts. 4 such circumstances are identified in this subsection. Note that this section should not be construed to authorize a U.S. or foreign lawyer to establish an office or other systematic and continuous presence in a jurisdiction without being admitted to practice generally there. The comments also discuss there's no single test to determine whether a lawyer's services are being provided on a temporary basis. Services may be temporary, even though the lawyer provides services in the jurisdiction on a recurring basis or for an extended period of time, as when the lawyer is representing a client in a single lengthy negotiation or litigation. Paragraph D is the in-house counsel subsection of this rule. This subsection identifies 2 circumstances in which a lawyer is admitted to practice in another U.S. or foreign jurisdiction and is not disbarred or suspended from practice to establish an office or other systematic and continuous presence in the jurisdiction to practice law. As we just discussed, subsection C of the rule permits a lawyer admitted in any U.S. jurisdiction to also provide legal services in the jurisdiction on a temporary basis. However, the comment to subsection D reiterates that except as provided in paragraphs D1 and D2 shown here, a lawyer who is admitted to practice law in another U.S. or foreign jurisdiction and who establishes an office or other systematic and continuous presence in the jurisdiction must become admitted to practice law generally in the jurisdiction. Finally, subsection E shows additional conditions for this paragraph D. Now that we've taken a minute to look at the model rule, I'm going to turn it over to Micah to talk about some real-world applications of the rule. Micah?
Thanks. You can go back to that last slide. Let me just talk about 5.5 in general for a minute. What is the point of 5.5? One is to protect the public. Okay. Two deals with quality control and understanding what's going on in a particular jurisdiction. And three really deals with the unauthorized practice of law. And what are we trying to do here? We're trying to prevent non-lawyers from practicing law. We're basically looking at whether or not someone has an office. When you mention continuous presence, continuous presence and quote unquote practicing law, again, have kind of varied definitions as you go from state by state. And often when you look at the nuances of 5.5 in different states, a lot of it does deal with whether or not you're holding out that you have a license there. So let's go on to the next slide. So what's happening, in terms of 5.5, and why is it such a timely subject, and why are people talking about it constantly now? A lot of it deals with really kind of the changing landscape of the workplace, even though issues related to 5.5 kind of predate things like COVID and remote practices. But a lot of it has to do with market pressures from increased competition. From other lawyers, that plays a big role in looking at 5.5. Changes dealing with modernization and globalization and technology. Globalization, obviously, a lot of law firms are all everywhere, and the competition is coming from everywhere. Obviously, changes in technology have played a big role in the ability to practice across state lines and to not kind of limit yourself to where you live. A lot of times when people are talking about 5.5, they're talking about access to justice, right? And the ability of people to access legal services. Typically, it's supposed to be for the underserved. You've seen in Arizona and Utah changes that are, designed to create more access to justice. Whether or not they've succeeded or failed might be, next year's CLE topic. But that's another area. The drive for uniformity is obviously a big deal, and one of the things that you'll find in this hour is that there's not a tremendous amount of uniformity from state to state. And also just the realities of today's law practice, in which, where we live or where we're licensed is not necessarily where we need to be in terms of the legal issues that come up and what clients need from us. The question is, do these artificial boundaries really protect clients when you're kind of limiting people in terms of where they can and can't go? So you're looking at economics. A lot of times you're looking at, what I call turf issues in regard to jurisdictions, competition from virtual law practices, changes to remote practices, again, mostly due to COVID and post-COVID, and then changes in technology and dealing with issues like e-filing, in which you can really be anywhere to practice law in many practice areas. We can go on to the next slide. So what's the history of the changes to 5.5, or proposed changes or attempted changes? It starts with a discussion by the 2020 Commission, which now dates back, 30 years, when they started looking at changes to the, coming about near the year 2000. And so now obviously we're in 2025, and a lot of the things that were talked about still have not come into play. The Association of Professional Responsibility Lawyers, April, of which I'm a member, proposed changes to 5.5 in a document in April of 2022. And then the ABA, the Center for Professional Responsibility, followed up on that sort of April proposal in January of 2024. That's sort of the last place I've seen things. But, sort of the key to the April proposal was, allowing you to basically practice law anywhere in the United States as long as you had a valid license somewhere. And the key to that was as long as you disclosed where that license was and where you were basically where you practice law. And so the concept of the April proposal is sort of along the lines of what we often tell people is like a driver's license. So if I was on camera, you would see me hold up my driver's license from the state of New Jersey, which allows me to drive anywhere in the United States. And then I have here my Pennsylvania law license, which allows me to practice law in Pennsylvania and no place else. And so what we want to do is try to get closer to the driver's license model and see some of those changes come into play. In the conversations that I have with people that are in April and within the ABA, we often debate whether or not changes are really going to happen anytime soon. And for the most part, it really deals with, again, it's an area that's owned or controlled by sort of the state bar and state bar regulations, and they're not going to, give up. They're not going to give up their sort of authority in terms of licensing and oversight of the lawyers in their particular state. You can move on. So I have here one example. This is just one example, the state of Missouri, that has numerous ethics opinions dealing with 5.5 and 8.5. 8.5 kind of often goes with 5.5 in terms of choice of law. And they're in Missouri, they're what they say is extremely limiting and very strict. And so the example I usually give is that I drive to Missouri. I will drive to Missouri again in August to take my daughter to college at Wash U. I will spend 3 days in a residence in Clayton, Missouri, and I may or may not log in and do work, right, for people back in the Northeast. According to some of these Missouri ethics opinions, I'm engaged in the unauthorized practice of law in Missouri because I'm sitting in the state, even though I'm on a laptop doing work that has nothing to do with the state. So if you look at Missouri as an example, they're one of those tougher, stricter states that are not as interested in modernization, I would say, in regard to the rules. And depending on where you live and what states you practice in, you always want to be a little bit more careful than the places that are a little bit stricter in regard to the interpretation of 5.5. Move on. Here's another example. This is a State Bar of Georgia formal advisory opinion dealing with 5.5, asking, can a lawyer provide legal services by remote means from Georgia while residing in Georgia when the services have nothing to do with Georgia other than that's your physical location? And so, again, I could be sitting in Savannah, right, which I've visited as well, and working on something that has nothing to do with the state. Maybe I live there, maybe I'm visiting, and so, in terms of that formal advisory opinion, what do they say? As long as I'm not holding out or representing to anyone that I'm licensed there, I'm not suggesting to any of my clients that I am licensed in Georgia, whether or not I take reasonable steps to ensure that the lawyer's Georgia location is not generally known, okay? And so basically not telling you that I'm sitting in Savannah on a matter that deals with Pennsylvania, and taking reasonable steps to correct any misunderstanding about licensing. So again, this is an example of a place where, you may very well, move to, right? You might not practice law in Georgia, but you might live there, and you might maintain your license somewhere else along with your clients and everything else. So those are some of the issues that you might look at in regard to how you represent yourself in practicing in a place where you might visit or live but not be licensed. Next. So state variations on Rule 5.5. This is probably the kind of the meat and potatoes of the program today, and it's really looking at each of the states and their nuances and their, whether they're looser or stricter, what they look at in regard to their interpretation of 5.5. And so, I wouldn't pay a lot of attention to just the names on this particular slide, you could look at any of the 50. There are some that follow the ABA model rules very closely, but most of them have made changes. And there's, some are stricter, some are not. So just as an example, like I'll start with Arizona, where they've expanded safe harbor for out-of-state attorneys. So it's expanded beyond Model Rule 5.5 in terms of allowing temporary legal services in the state. They have explicit federal and tribal law exceptions. Out-of-state attorneys must inform clients that they are not admitted to Arizona and obtain informed consent before representation. They have separate rules as they deal with in-house counsel and dealing with pro hoc. Pennsylvania is very interesting because they just made changes just this past fall to some of their rules of professional conduct. And in addressing 5.5, as opposed to most of the cross-rule comparisons in other states that deal with jurisdictional components, they actually basically cross-reference 5.5 with 7.1 to 7.3, which are the advertising rules. And so they basically address restrictions on advertising and solicitation, that lawyers not admitted in Pennsylvania cannot advertise legal services to prospective clients in the state, and that communications about legal services must comply with 7.1 to 7.43, ensuring they're not false or misleading. So this is one of the few times where a state has basically, specifically referenced the advertising rules by number in regard to a cross comparison with 5.5. In New Jersey, they've expanded the scope for out-of-state attorneys, but they limit it to certain components of transactional work under 5.5b3. There are things that they allow people to do in terms of transactional work as long as they're not going into court. They have very strict pro hoc BJ admission requirements that you basically have to pay a filing fee, and you must obtain admission. And you must associate with a New Jersey licensed attorney who actively participates in the case. So that's not the case in many states. It is the case in New Jersey. They have unique occasional practice standards, and then again the federal and in-house counsel exceptions. In Connecticut, again another state that could be a little bit complicated if you ever move into or practice across the lines in Connecticut. They have certain rules in dealing with reciprocity-based multi-jurisdictional practice, allowing temporary legal services by out-of-state attorneys if their home jurisdiction grants similar privileges to Connecticut lawyers. So that's a very unique component. Like, we'll let you function here temporarily if your home jurisdiction lets our lawyers function there. And so that's an extremely unique component. Attorneys from jurisdictions that do not offer reciprocal MJP can't rely on Connecticut to practice temporarily, to allow them to practice temporarily in the state. They have a mandatory notification requirement. Dealing with out-of-state attorneys must notify the Connecticut statewide bar council, and you have to pay that prescribed fee to engage in that temporary practice. So that's among the components. They have other things dealing with house counsel registrations and things of that nature. Other states, Montana, for example, much stricter than the ABA 5.5. They don't allow any temporary practice. They have very strict pro hoc rules. And their disciplinary oversight also reminds you that it includes aspects of advertising and solicitation. In North Carolina, again, narrower on out-of-state. Their pro hoc does require North Carolina counsel, and they are very strict in letting you know that you are under their disciplinary arm. And we'll talk a little bit about North Carolina a little bit later in the hour. Ohio, explicit remote practice allowance, pro bono exceptions there that are a little bit different. New Hampshire has a little bit different rules in regard to remote practices. Oregon has limited temporary legal services, much stricter pro hoc, and they have that line about being reasonably related to your practice in another jurisdiction. So if you're asking to practice there, it has to be something that you are allowed to do where you live or where you're licensed. And they also remind you about the role of advertising and the solicitation rules as it relates to that. State of Washington expanded safe harbors for state. Illinois has some specifics in regard to remote practices and are a little bit stricter with unauthorized practice of law. So those, as you can tell from just reeling through a couple of those states, and you really need to check not just your own state, but obviously the states that you're going to practice in. When we're dealing with MJP issues, you're really going to deal more with states that you're not licensed as opposed to states that you are. Kate, did you want to add anything here?
Yeah, I think you covered all the states. That was great. I did think the Connecticut commentary was really interesting, and it seems like that has really been one of the more recent states to take action on this issue. And they're saying, like, if you're sitting in Connecticut practicing the law of the state where you're licensed, like, you're basically not practicing law in Connecticut. So they've, it seems to me, really tried to modernize and, work with the technology and acknowledge that, people are going to work remotely in Connecticut.
Yeah, and Connecticut is difficult in the advertising arena as well. There are times where I've actually had law firms take a campaign where I just pull out of Connecticut entirely just because I don't feel like dealing with it. But I've also found that over the course of time, as we all know, in whatever states we practice in with our state bars, the state bar goes hot and cold in regard to their level of interest and level of enforcement. I've interacted in some fashion with matters that are in Connecticut for I don't know, at least 25 years, and there were times where it was kind of a red hot issue there, and then other times it kind of faded, and it kind of goes back and forth. So that's one of the things that you can't really teach in a CLE, and it's kind of hard to talk about. We kind of all know where we live, what our state bar looks like, but kind of how they operate and how they function and how friendly they are or not really plays a role in a lot of the things that we kind of do on a daily basis. Even on when I reference here Illinois, Illinois had a matter dealing with unauthorized practice of law where an attorney, all he did was he sent a demand letter on behalf of a friend of his. He wasn't licensed in Illinois, but he sent the demand letter to someone in Illinois, and he wasn't licensed there, and he got in trouble. And so, there's situations like that are kind of real life, and they come up a lot. So, you kind of want to look at, whether, the states that you're interacting with, that you're dealing with, that you're going to, do they mirror ABA 5.5 for the most part? Are they substantially different, like New York or Texas or California? Do they have fees involved, like New Jersey and Connecticut among them? Those are all the types of things that you want to look at when you're looking at the state variables as it relates to 5.5. So we can go to the next slide. So where can you practice, right? Where can you practice now? And I just referenced, whether, I often look at whether a state is friendly or not. There's states that I consider to be a little bit friendlier, like D.C. and Arizona and Utah. There's states that are a little friendlier, I think, personally, from California for federal practice only. D.C., really the only place that you can fee share with non-lawyers. There are different components that come into place. And so what do you want to look at when you can look to see where you can practice now? We'll go to the next slide. So where can you practice temporarily, right? And again, like the definition of temporarily is kind of wide, it's wide ranging. A lot of attorneys wrongly believe that they can just practice anywhere and they'll just get admitted pro hoc, right? Like I know plenty of folks where they're like, oh, we just get admitted pro hoc. And again, you can't just rely on that as an expectation. And some states, if you go that route too many times, then they're going to boot you out the next time. But pro hoc is obviously one way to practice temporarily. Admission by motion. A lot of the pandemic exceptions continue to be extended and kind of have changed the way that you can practice in regard to being able to be somewhere temporarily. And there are exceptions for things like pro bono and UBE. We'll talk about military spouse in a second. So you really want to look at, what are those sort of, how can I practice somewhere safely? One is to, obviously retain local counsel. That's probably the safest way. There are varying rules in regard to ADR and, whether or not ADR comes into play in the same way as if you were going into court. And again, the ADR rules vary from state to state. And I mentioned before the relationship to the home state. What you don't want to have happen is what happened in like sort of the landmark case that's still good, I think. Bierbrower from 1998, which is, when a California subsidiary of a New York client, they're in a contract dispute, firm travels to California, meets with the client, files an arbitration claim, negotiates a settlement, and then the Bierbrower is found to have engaged in the unauthorized practice of law under the California Code. And that cost them over $1 million in legal fees. So people often look at Bierbrower, even though it's from 98, in regard to sort of that combination or that crossover between 5.5, where a lawyer can practice, and 8.5, dealing with which jurisdictions rule and are kind of in play. So those are the things that you want to look at from the temporary standpoint. Going on to the next slide. There's the military spouse attorney exception. And, Virginia was one of the worst in the country in this regard, because they had a requirement that any military spouse attorney who needed to make a courtroom appearance had to be supervised by their local counsel for the duration of their time in the state. There's something called the Military Spouse JD Network, which is a 1,000-member bar association that's created to help military spouses, of whom 92% are estimated to be women, with the unique professional challenges that other attorneys do not face. And although most states have now adopted some form of military spouse attorney exception or allowance, Florida says if it's reasonable, New York says if they have the ability to accommodate, Mississippi looks at it from a place of protectionism, and in many places there are still onerous application fees, but this is one of those areas where you look for that exception if you are a military spouse. You're moving around and you're trying to maintain your career and practice. Go to the next slide. Where can you practice permanently? Obviously there are components of federal law or federal practice in which you don't need to be licensed in a particular state. It's a purely federal practice. It's not across the board always, but for the most part, or in many practice areas, a federal practice can permanently practice in a state in which you are not living or licensed. There are, numerous exceptions in most states dealing with in-house counsel and what a GC or a in-house legal department can and can't do without being licensed there. So it's not unusual, obviously, for a general counsel, to be based at, in state X, but their license came back from, is from New York, and so they can work that way. Related to pending mediation or arbitration, as I mentioned earlier, there are exceptions in regard to ADR in most states. Whether you have local counsel, again, that's often the easiest. I always tell firms, when in doubt, make sure you have local counsel just tied to you. There are exceptions for pro bono practices, and we mentioned authorization by local jurisdiction with limitations. Go to the next slide. So how do you maximize the versatility of your license? And so, what is it that you look to when you're trying to, practice in as many areas as possible, in as many states as possible, without being licensed all over the place? And so, so one of the areas that we look at are states with uniform bar exams, in which it will allow you to practice in more states than one. We talked about the nuanced RPC 5.5 that works for your purposes. So, for example, you might look for, Arizona is a very good example. Like I know a lot of law firms that look to either relocate or open or do something in regard to Arizona because of their alternative business structures and other opportunities. But when we talk about all those nuances of 5.5 from state by state, you might very well look at those state by state rules and sort of determine what places you might want to get more business or you might be more interested in terms of where you set yourself up. Reciprocity with the states you're interested in going to. We talked about that a little bit earlier. I thought that Connecticut rule is pretty interesting, just because it's kind of like, well, if you don't let my people in, I'm not going to let your people in. So that's sort of the way they look at it. But looking at reciprocity obviously is critical and key in terms of MJP and avoiding UPL. Picking a federal practice, again, like that's another way of maximizing your license, being able to use it in more places than one and more across the board. And we also talked a little bit about in-house counsel. I had a situation that came up recently with one of my lawyers. He was switching firms, and his new firm didn't want to pay one or two of his state licenses. And I thought it was ridiculous because I looked at the rules, and basically in order to maintain that license, it was going to cost him, even if he never used it, right? Like even if you never use it, it was going to cost him about $250 a year to maintain. You can usually assume that CLE is going to work across the board. He wasn't really going to use it, so you really didn't have any, insurance concerns. It was just a matter of really keeping it active. And I felt like it was of value to have an active license in your back pocket and also to use it from a business development standpoint. And so, I basically had the firm pay it. But it's a matter of, you kind of want to be able to show that you can go in as many states as possible, and you want to kind of maximize the versatility of your license. Go to the next slide. So what are some of the hard and fast limits? Practicing in a different state than barred, but within the rules, right? Like, you've got to be careful about just trying to go to the well too many times in a particular state. A lot of them deal with, like, what I say, don't dabble in state law. They will often look at whether or not the engagement and the things that you're doing in that state really rely on things that are very specific to that locale. And so, if you're dealing with something where kind of the practice of the law is, pretty much the same across the board, it's not going to be any different really in, South Carolina than it is in, Michigan, right? Like, but if you're dealing with something that's very specific to state law, and they don't feel like you have that, you have that expertise, you have that understanding, that's an area that you want to try to avoid, dabbling in state law. Identifying where you're barred and why you can practice there. I know a lot of firms that I know they purposely don't do that, right? Like I sometimes look at some attorneys and I look at some law firms, I look at their website, I'll sometimes look at their letterhead, and there is no identification whatsoever of any place that they're licensed. It doesn't mean that they're not licensed anywhere, but they I say that they purposely don't want you to know because they're trying to sort of cast as wide a net as possible. But I always have my law firms make it very clear where they are licensed and where they are not in terms of identification. And as you recall from what I said earlier, dealing with those nuances of 5.5, a lot of states very clearly say, like, you've got to tell us that you are or not licensed here. In Michigan, they have it's very specific. Like, you can do this or that here, but you've got to make it very clear to people you do not have a Michigan license. Certificate to client, having a certificate to client about malpractice insurance in Oregon, or additional requirements as they relate to registration as an entity in New Jersey. They're very, again, specific, so they deal with the state that you're located in, and understanding some of those nuances and those requirements and those registrations, and a lot of times those fees that come into the practice. Go to the next slide. So what is bar reciprocity, and how does it work? And so a lot of it, obviously deals with discipline and enforcement. And so, only certain states do allow, reciprocity. You have to look at their CLE requirements, and you have to look at those requirements. But again, bar reciprocity. There's some states where they're friendly with their neighbors, and there's some states they're not. But you have to kind of look to see, what plays in your neck of the woods. You can go to the next slide. Bar reciprocity in terms of adding new jurisdictions. So, what do you want to ask when you're trying to add a new jurisdiction to your practice or to your firm? What are the obligations that come with the addition of the new jurisdiction? What are some of the hidden costs? Are there specific CLE requirements there that you don't have where you are? And what state bar dues are required in pretty much every state. And so you kind of want to look at all of those components when you're deciding whether or not you want to add a new jurisdiction to your practice. Just getting reciprocity isn't necessarily free. You've got to look at all of the potential costs and requirements that are tied to them and determine whether or not it's worth doing, or in many cases, is it a one-off situation where you're better off just getting local counsel or co-counsel as opposed to adding the jurisdiction to your, let's call it your portfolio. So, how did I get involved in, caring so much about 5.5? If you were on this program last year with me, I talked all about the various issues as related to advertising, marketing, and solicitation. And when I first started working on that area of law practice in terms of marketing ethics, it used to be, what I really spent my time on and what I looked at were all those, 7.1 to 7.4, advertising rules. I looked at disclaimers. I looked at certain languages you had. I looked at things that you weren't supposed to do, like, certain use of terminology, like, specialization or expert, and, whether or not you had attorney advertising on your website and whether you needed to follow your ads, all those types of things that used to be sort of the core of my practice. But over the course of the last, decade or two, it really became more about issues of multi-jurisdictional practice and unauthorized practice of law. And so they really kind of flow together almost to the point where it's, I'm more worried about MJP and UPL than I am about 7.1 or 7.2 in terms of making sure that a marketing campaign or the way that a law firm behaves is ethically sound. So, how do you safely market your practice? When we're looking at advertising, marketing, solicitation, those RPC nuances that we talked about earlier, obviously the tie-in with MJP and UPL. And, what do I look at? I look at enforcement mechanisms, and I look at how strict a particular state is in regard to their enforcement and, honestly, whether they care or not about some of these rules and regulations. As you can probably tell from some states, they care greatly, and then there are other states that, to be honest with you, I think we all know that it's not a great concern with them. And so a lot of times, even when we're looking at a marketing campaign for a firm, a lot of times we need to determine whether or not we should just associate with local counsel that is clearly licensed in a place that we're marketing into, or that we're looking for clients, or whether or not we can kind of go it alone. Next slide. So so this is a slide that this is a billboard that I've driven by in Philadelphia. They're big. If you're in this area, they advertise heavily Pond Hockey. And I'm not, saying anything about the firm itself. I don't really know a ton about them. All I know is that this billboard says all legal matters, anytime, anywhere, right? So is that true, right? Like, are they really practicing anywhere? So if I call that law firm this afternoon and I say, hey, I've got a Montana matter. I'm in Montana. Do you have a Montana lawyer? Are you licensed there? Can you help me with my intellectual property matter? Again, maybe the answer is yes. Maybe they can, but I would suggest that the answer would not be. And so, you have to kind of be careful about the way that you market yourself, and whether or not what you're saying is legit, right? So, could I sit there in the disciplinary committee in Montana and call Pond Hockey and go like, hey, you're not allowed to practice here. Why are you saying that you can? Again, maybe this example is a little bit far-fetched, but it gives you a little bit of an idea of what you can and can't do. What I usually look at when I'm looking at a campaign, where do we have attorney licenses? Where do we have offices? And then in certain matters, what states are you targeting in the advertising? And is it a matter that, that somebody can specifically, target you based on, are you targeting a particular state? And can that state say that you're targeting them and maybe you're not licensed there, maybe you don't have an office there? Now, sometimes, like you can make quote-unquote mistakes. In Florida, the bar dropped a grievance against Kennedy CMK, and I guess it was about a year ago, because, they had said some things on their website. They made the change, they complied, and they dropped it. And so you want to, again, like if you haven't had issues before, and you make a mistake, a lot of times you're given the opportunity to correct it. But if you've made the mistakes before, it's a little bit of a different story. When you're looking at solicitation of new clients, like what are those, there are three exclusions to those solicitation rules typically. One is if it's another lawyer. Another is if it's a family member or someone you have a prior relationship, or if it's someone that you routinely use your services. Outside of that, it's considered it's considered an improper solicitation. But those are the things that you kind of want to look at in terms of the areas of your practice. If you go on to the next slide, one of the things I spoke about earlier was, like who are we competing against? And one of the things that we're competing against, and for a lot of firms, is you're competing with virtual law firms. A lot of us, we know who they are, right? Like there are a lot of firms that are virtual, and they're everywhere and they're nowhere. And so, what states are you supposed to comply with? I had a virtual law firm contact me at one point, and I kind of pointed out to them that that they were committing numerous ethics violations because of the way they had presented themselves on their website. I'd be happy to help them, and then I never heard from them again. But they shall remain nameless. But like you're competing against virtual law practices, and then you're competing against firms that do have licenses and or offices in all 50 states, and it becomes very difficult, for a lot of the smaller and mid-sized law firms that are trying to compete across the board. How do I compete when I only have licenses in one or two places, and I'm competing against firms that can say, like, hey, I can do everything for you everywhere because I have offices everywhere, I have licenses everywhere. And so, these are the types of things that create sort of the need to create a little bit more flexibility in 5.5. You can go to the next slide. This is a slide from last year. If you saw it, if you were here last year, you're like, I saw that slide last year, and you'll see it again today. It's an old slide because Bryce Harper's on the injured list, and he's up there on the scoreboard. But I talked about the Morgan & Morgan effect, and again, the impact of Morgan & Morgan on a lot of firms, because again, they do, the difference is, like one of the firms I showed you on the prior slide, they do have offices in, I think, all 50 states, and they do have actual licensed attorneys in all those places. So this isn't a case where they're just, this isn't a case like, Top Dog, where they don't really have they're not a firm with offices and licenses everywhere. They're more, to me, they're more of a lead gen company than they're a law firm, but that's my personal opinion. But the Morgan & Morgan effect is, again, created a need for a lot of firms to be able to practice in more places. They get hit there, with "you're not from here" type advertising, and you should shop local. But the reality is that, firms like Morgan & Morgan have really kind of changed the landscape in terms of competition and the need to be able to, again, practice in more places. Go to the next slide. So discipline for multiple states and entities. You can't practice anywhere in the U.S. if you're disbarred or suspended in a state. This can affect federal practices also, and don't presume they match up in time or procedure for reinstatement. So if you've ever had any issues or problems with discipline, whether it's disbarment or suspension in a particular state, often there can be reciprocity there, and you're not sure when you might get what you might get when you may be reinstated. You have to look at sort of the discipline function for different states. Go to the next slide. So this is an interesting case. This actually just came to a conclusion. This is an attorney who was practicing in immigration law, dealing with a matter of dealing with funds and trust account. He lives in New Jersey. He lives in North Carolina. He's not licensed there. He was licensed in New York. He was again, federal practice, immigration lawyer, licensed in New York, not licensed in North Carolina, lived in North Carolina. And he ran into some trouble there, and he came back and said to North Carolina, like, you don't have jurisdiction over me. Like, I don't even, I'm not even a member of the bar here. I'm licensed in New York. And he lost, right? Like, so he was found, he was disbarred in North Carolina. He was subsequently also disbarred in New York, and his argument that he didn't fall under North Carolina, failed. And so, his argument that you can't discipline me, I'm not from here, didn't work. There was a matter I read about in Law 360, I think last week, very similar in nature. It was a Florida attorney who was telling North Carolina, you can't discipline me, I don't live here, I don't practice here. And in that case, there was a suit against a North Carolina resident. His former partner had already been suspended in North Carolina and New Jersey. He had made one single appearance in federal court in North Carolina, and that was considered enough to fall under the umbrella of North Carolina. So, just always a reminder that, of what umbrella you fall under in terms of where you practice and what you can and can't do. Next slide. If you want to go look at sort of those state-by-state differences, you can log on. The ABA has a jurisdictional sort of comparison chart. You can look at the variables and the variances in terms of what each state looks at or does in regard to 5.5. And then there are other things that come up, like in New Jersey, there's Opinion 745 that deals with referral fees. And that's certified trial lawyers can't pay referral fees to out-of-state lawyers. They're just different things that come up outside of 5.5 that sort of come into play. We'll go to the next slide. And then, we've talked about this a little bit earlier, but sort of looking at that intersection of 5.5 and 8.5, as we just talked about in regard to the North Carolina example. 8.5 basically is like, you're under our jurisdiction. 5.5 is this is where you can practice. And so you kind of want to look at those nuances and those changes. Next slide. And then, there are places like New York that still has a physical office requirement. It's one of the only ones that still exist. And it was interesting because it looked like they were finally removing the requirement. They had one in New Jersey as well that got lifted in 2013, and then New York was one of the few that was still remaining. And so even in the House and Senate in Judiciary Law 470, they basically the ability to no longer have a physical office requirement. It was somehow then rejected by the governor. I don't even know how that exactly works there, but the governor sort of, I guess, sort of vetoed it. I'm not sure what the term is, but I figured like either the real estate brokers or maybe the trial lawyers had a really strong lobby. But New York is one of the few places that still has that physical office requirement. And when you're dealing with New York and you're looking at things there, you want to be very careful about what you can and can't do without a physical office. You can go to the next slide. You can read this, the remote practice rule. Again, you can be in-house if you're in good standing elsewhere. This is an ethics opinion from last June dealing with, avoiding UPL for in-house. And then next slide. And then, what's next? Again, can we get 5.5 to the place where it becomes a little bit closer to a driver's license, where you can practice in more places and more, without difficulty. I'm not a big believer in 5.5 changing anytime soon, despite, all the attempts by April and ABA CPR and other folks to make it a little bit more easy. I still look at, whether, the enforcement mechanisms of a state. We're trying to, create some level of consistency and adjust to market pressures. I think a lot of these legal law organizations like April will continue to kind of push and see if we can get states to become a little bit more, even in terms of their interpretation and understanding and allowances of MJP under 5.5.
Great.
Yeah,
Thanks,
well,
Mom.
great. Well, thank you so much, Kate and Micah. Kate, unless you have any last thoughts before I open up our Q&A.
The only thing I was going to point out, just for the benefit of the audience, it's just been such a great comprehensive presentation by Micah, was just that formal opinion 504, that if you have questions about what jurisdictions' ethics rules are going to apply, that's really helpful because it offers hypotheticals. The ABA committee that developed that opinion analyzed those questions in the context of fee agreements, law firm ownership, lateral lawyers. So again, if you're looking for guidance on that, I would check out that opinion.
Great, thanks. Well, at this time, we would like to welcome you to ask questions. There's a dialog box marked Ask a Question on the left-hand side of your screen. Please click the box and then type your question in the dialog box. We generally receive a lot of great questions. Unfortunately, we won't be able to address all of them in the time frame that we have today. So with that, we're having a lot of comments come in about how beneficial this webinar was today. So thank you again, Micah and Kate. And with that, our first question is, Would you advise your law firm clients to simply seek reciprocity in the states they want to practice in as the safest way to avoid multi-jurisdictional practice issues?
Yeah, I mean, again, it really depends on the matter and how how aligned it is to sort of the like the sort of state laws, as I had said earlier. The safest way is obviously always to have local counsel or co-counsel when you're going into a jurisdiction where you're not licensed. But in terms of reciprocity, if you do think it's an area that that's going to come up more than once, and there's value in it in terms of your business. So so for example, if you're dealing with a client and it's a one-off situation, I'm probably just going to get local counsel there. But if it's something where I'm like, what, I might do this 20 times, and maybe it's the state right next to me, or maybe it's a practice that's burgeoning in another place, then I'll probably make that investment in reciprocity.
I thought it was interesting, Micah, how you referenced the pro hoc admissions or motions to be pro hoc, and how there probably is a limit to those at some point. Like you said, like how many times can you go back to the well? That was something I hadn't considered before.
Oh yeah, like you see, and I mean I read about that all the time. When I'm we were talking before the program about my reading Law 360 every day, and so I often see situations where a firm is like, okay, where a judge will say like, listen, you've been here one too many times. Or you can't just keep coming back here. And there are a lot of folks that believe like, they really do think like, oh, I'll just get admitted pro hoc every time. And the same thing goes for, for advertising and solicitation, is that you can't advertise based on the idea that, well, I will, if I get the matter, like I'm going to just go pro hoc in that state. Like you're actually not allowed to market based on the concept that you might get admitted pro hoc.
All right, great. Another question that came in. Do you have any war stories to share about the issues with these firms that are claiming to be 50-state law firms?
Well, I think it's yeah. I mean, I mentioned earlier the firm that asked me a couple questions and then hung up the phone because I don't think they wanted to hear my answers. But yeah, there's there are problems with with competing against folks that have virtual law practices, or in terms of firms that basically don't go through and look at the nuances in all those states. So just as an example, this isn't completely on point, but when I was talking about Morgan & Morgan earlier, they had a lawyer who was a competitor sue them last year in Arkansas, based on their failure to abide by, some nuanced rule under 7 point something, right? It had to do with, I think it was the use of testimonials. But whatever it was like one of those things where, they kind of slipped in terms of not abiding by a specific rule in the state of Arkansas. And they're sitting there, marketing into 50 states. They're usually pretty good about compliance there, but they missed something, right? And so they missed something. They got sued. I thought it was kind of a frivolous claim, and it went away, but it did lead to sort of a filing based on missing something in the state, and that's what I often look at. Like, so if you look at one of these law firms, like that firm that I had earlier up on the slide, that has offices in 50 states, like I can't speak for them, I don't know them. But I would suggest that they probably, if I really dug into it, they probably don't abide by everything in all 50 states that they're licensed. Maybe they do, but most of the time there's something that you're going to miss. And so that's the flip side of it. There's one of the states where you're licensed. Maybe you're licensed in Montana and you miss some of the sort of the strict variables, and somebody calls you on it. Probably more likely a competitor than the state bar, but it could be either one of them.
Okay, great. Well, at this point, we are out of time for further questions. We are at that 60-minute mark. And on behalf of Attorney Protective, I'd like to thank all of you for joining us for today's webinar. And I'd also like to thank our speakers, Micah and Kate. Thank you so much, and have a great day.